I'll now call case numbers 117518 and 117519, Shelby Montgomery and Scott Bennett versus Patrick Sala.
May it please the court, I'm Assistant Solicitor General Dwight Carswell, appearing on behalf of Patrick Sala in the state of Kansas. I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. Back in 2010, Kansas Highway Patrol Trooper Patrick Sala was informed by another Highway Patrol officer that a passenger in a car was waving around a knife and that the license plate on the car didn't match that car. Trooper Sala came up behind the vehicle and turned on his lights and sirens. The vehicle at that point was traveling north on Topeka Avenue here in town. The vehicle, which was being driven by Robert Horton, put on its right turn signal, turned off onto a side street. But then rather than stopping, Horton accelerated and then turned south onto Kansas Avenue. They then proceeded through a red light at 21st Street. There was a car on either side of the intersection at that point, but they both stopped, thankfully, presumably because they'd been alerted by Trooper Sala's lights and sirens. Horton then continued to accelerate and reached speeds in excess of 100 miles per hour in Trooper Sala's estimation. By the time Trooper Sala had reached the Wonder Bread store just south of 25th Street, he decided to terminate the pursuit and began to let up on the gas. However, because he was still speeding, he still had his lights and sirens on. Horton then continued and ran through the red light at 29th Street, struck a car occupied by the plaintiffs in this case, and injuring them. The plaintiffs turned around and sued Trooper Sala in the state of Kansas. The district court granted summary judgment to the defendants, finding that the plaintiffs had failed to establish causation. The plaintiffs appealed, the Court of Appeals reversed, and we petitioned for review. There are a number of issues in this case, and I'm happy to answer questions about any of them, but I'd like to focus on causation in fact, recklessness, and discretionary function immunity. On causation in fact, the district court correctly held that the plaintiffs had failed to produce any evidence that would allow a jury to determine that if the pursuit had terminated earlier, the collision would not have occurred.
How do you get over the expert basically saying that's the case?
The expert, in a very conclusory... Okay.
Yeah, it's very conclusory, speculative, but that's what the expert said. And is that enough to put it before the jury?
No, we don't think so. Again, it was just a conclusory statement. There was no basis for it. There was no explanation of why that's true. And in our view, speculation from an expert is no better than speculation from anyone else. It's not enough under this court's decision in Yount to satisfy the plaintiff's burden.
And as I understand it, the initiation of the pursuit is not being questioned here. The only question here is in terms of causation is the time of cessation.
That's my
understanding. Is that
That's
correct?
mine as well, yes. I believe plaintiffs are arguing that when Horton ran the red light at 21st Street, that's when the pursuit should have terminated. And the district court was correct on causation for two general reasons. First of all, the discussion about what Horton would have even been able to see. The district court went in some detail through the layout of the road and how there was the curve. Now at 25th Street, there was the hill. And so by the time of 25th Street, it's next to impossible that Horton would have been able to tell that the pursuit had terminated. So that only leaves the 4-block period between 21st Street and 25th Street. And in that period, it's not as if Trooper Sala could have immediately terminated the pursuit. Again, he was speeding, so under KSA 8-1506, he had to leave his lights and sirens on if he had decided to terminate the pursuit, until he had got down to the speed limit of 5 miles per hour.
The district court pointed out that there was no evidence as to what the Horton was experiencing. In other words, we don't know if his windows were shut. We don't know how he was even knew he was being pursued when they lost vision. Was there anything produced that suggested Horton knew that the pursuit stopped or when it stopped or anything like that? Anything from his perception?
I don't believe there's any evidence from Horton in this case other than maybe statements that are in police reports or that sort of thing. But the pursuit didn't actually terminate formally until the collision happened at 29th Street. Trooper Sala did decide to terminate it, but he had still his lights and sirens on, as I indicated. And as I was saying, Trooper Sala, if he had decided to terminate the pursuit at 21st Street, would have had to slow down to 35 miles per hour, at which point Horton still would have been traveling at 100 miles per hour. There would have been quite a bit of distance behind them. Even by the time Trooper Sala could have turned off his lights and sirens, it's very questionable whether Horton would have even been able to notice that. Much less, as the U.S. Supreme Court noted in Scott v. Harris, there's no effective way to communicate to a pursued suspect that they're no longer being pursued. Even if Horton had somehow seen the lights go off, he still could have thought that some other officer was going to come along and try to arrest him, or the police were setting up some kind of roadblock or whatever. And that leads to the second point supporting causation, which it's just totally unclear how Horton would have reacted if he had seen Trooper Sala terminate a pursuit. It's just as likely that he would have continued to flee to try to put as much distance between himself and the officers as possible.
Counsel, are we able to tell how long it was between the time pursuit ended and the crash occurred?
Well, again, I think formally the pursuit ended when the crash occurred. Trooper Sala decided to terminate the pursuit, according to his testimony, at the Wonder Bread store, which that was just a matter of seconds before the crash. The entire pursuit lasted about a minute and a half from the red light at 21st Street, which is where the plaintiffs claimed the pursuit should have terminated, until the crash was about 42 to 46 seconds. So,
Okay.
I mean, we're talking a very short period.
If we take the facts in the light most favorable to the plaintiff, as we must on a summary judgment motion, would you say 40 to 46 seconds then? 42? 46?
46 seconds, if in the light most favorable to the plaintiffs, from the time Horton ran the red light until the collision.
Okay. With that long a time period, why is it purely speculative that he would have stopped or slowed down so as to avoid the accident? It seems like a fairly long time period for him to do something different.
Well, again, for two reasons. One is whether he would have seen the pursuit terminated. After 25th Street, he wouldn't have. So then it becomes the question, as I was discussing, between 21st and 25th. And then secondly, at least for a brief time period, it seems just as likely, if not more likely, that a suspect who's being pursued and could fear that some other officers coming along, that officers are trying to stop him in some other way, will, at least for a short period of time, at least 40 seconds, continue to drive quickly to try to put distance between them. Again, the U.S. Supreme Court made that same point in Scott v. Harris, and it's certainly reasonable. And plaintiffs haven't produced any evidence about what's typical in these type of cases.
So let me just clarify something from Judge Lieben.
Sure.
Is it 40 to 42 seconds from when he decided, when the expert said decided he should not pursue somewhere around 21st Street, to when the accident occurred, or between the time in which the expert says he should have exercised his discretion and stopped the pursuit, and from when he did, when Salah actually did?
It's the former. It's from the time he ran the red light, which is when the plaintiff or the expert said that he should have stopped until the collision.
The collision.
Yes.
But isn't the question the not stopping the pursuit in a timely way from when he did actually do it?
I think that's correct, especially when you get into the interplay between recklessness and causation. In our view, I also want to focus on recklessness. And there, I mean, the question is, at what point, assuming our view is that the pursuit was never reckless, but if it was reckless, the question then becomes when and how that affects causation. And we just don't think that there's any way you can find at the 21st Street light that was reckless. After all, the cars on either side of that intersection had stopped because of the lights and siren. And again, this, as we mentioned in our briefs in detail, and as the district court went through, although it didn't find for us on this fact, the Kansas Avenue is a 4-lane road. It was nearly deserted at this time of night. There was only one other car on Kansas Avenue itself between 20th and 29th
Is that
Street.
issue before us? The negligence or recklessness of the pursuit?
I believe it is. The state cross-appealed, and then we petitioned for review on that issue.
Okay, walk me through that, because
So the state and the district court
my
raised...
understanding, I'm sorry to interrupt, but my understanding is this was resolved based on causation.
That was what the district court decided. The district court also rejected a number of alternative theories that the state made. The state then cross-appealed from that, and we were cross-appellants in the Court of Appeals. And then the Court of Appeals resolved those issues against us. They addressed those in their opinion. And the state petitioned for review, specifically listing all those issues.
Okay.
So I do believe they're before this court. And as this court discussed in Robbins, recklessness is a very high standard. It's akin to the crime of reckless driving. It's substantially more than just negligence or carelessness or just a misbalancing of risk. It requires truly egregious conduct, like the cases cited in Robbins for that proposition support. Like, for instance, District of Columbia v. Walker, which is one of the cases Robin cited. In that case, the officers were pursuing a car that they suspected was stolen, which was also a suspicion here in addition to the knife waving. The pursued suspect in that case went the wrong way on a one-way road, ran through a couple red lights, reached speeds of 90 miles per hour, and the court still said that's not reckless. The same is true here. Again, given the road conditions, the fact that it was nearly deserted, given the officers' need to apprehend the suspect for a variety of reasons, this just doesn't rise to the level of recklessness. And finally, on terms of discretionary function immunity, the Court of Appeals held that that doesn't apply because there was a duty specified by statute. This court has rejected that argument previously, and it's obvious if there were no duty in the first place, then there'd be no need for immunity. So the fact of a duty by and of itself does not negate discretionary function immunity. The question is whether the duty is clearly defined, as this court has said sometimes, or ministerial might be another way to put that. Here, where it's just a vague duty like negligence, or in this case, recklessness, discretionary function immunity is still available. And this court's cases haven't been entirely clear and consistent on discretionary function immunity. At minimum, it seems that the federal test for that should be used. That's the Berkowitz-Galbert test. And under that test, as the U.S. Supreme Court discussed...
Well, what's the interplay between the immunity and 1506D? What if there's immunity? What purpose is there of 1506?
Well, 1506 creates a duty, but
right.
Just like there's not a duty not to be negligent in other contexts, the existence of a duty doesn't render discretionary function immunity inapplicable. We presume that even if there's no tort liability, officers will nevertheless, we hope at least, will continue to abide by their duties that are specified by statute. There may be employment ramifications if they don't. And also there could be criminal ramifications, especially given that this court said the recklessness standard in that case is akin to the criminal standard for reckless driving. And there are cases where officers pursue in really egregious circumstances where they are prosecuted. So the fact of a duty just doesn't automatically give rise to tort liability. And in fact, if it did, then there'd be no point of having the immunity provisions of the Kansas Tort Claims Act, because they wouldn't apply if there never were a duty in the first place. And under the Berkowitz-Galbert test that I mentioned, in Galbert, the U.S. Supreme Court said that when there's a policy that specifically delegates discretion to an official, the exercise of discretion pursuant to that policy is presumed to be protected. And that's exactly what we have here. The Kansas Highway Patrol has adopted a policy that gives officers discretion after considering a number of factors as to whether to continue a pursuit. Trooper Sala was exercising that discretion here, and so his pursuit should be immunized as a discretionary function.
Is the discretionary function question entirely overlapping the standard of care question?
No, I don't believe so. I mean, even if...
Is your argument that the trooper had discretion to act outside his or her standard of care?
Well, the way the discretionary function immunity is phrased, it's discretion regardless of whether that discretion is abused. So even if he somehow miscalculated, that could still be a discretionary choice that's protected.
So your argument is that the law enforcement has the discretion to drive in a manner that violates the standard of care.
I wouldn't put it that way. I'd say the decision whether to continue a pursuit is a discretionary decision, even if somehow they get that discretion wrong. If that discretion is abused in terms of the statute, they're still protected under that immunity provision.
So it always come in. How doesn't immunity always come into play in this case? In these cases,
in police chase cases, very well.
Or in any police action. I mean, I have a hard time understanding how a police officer would ever not be immune.
Well, this court has said the plain language of the discretionary function, yes, suggests any exercise of discretion. This court has said it can't be that broad, and so it's got to be limited in some way. Now, this court's cases have not been entirely clear as to what that standard is. In the state's view, if it's either the federal standard at minimum, or we think the better standard is it protects discretion that a government official is specifically authorized by virtue of their position to exercise. So in this case, again, Trooper Sala was specifically authorized to exercise discretion about whether to continue a pursuit. The fact that he may have got that wrong, we don't believe he did, but even if he did, he's still immunized under the Kansas Tort Claims Act. See, my time is up unless there are any further questions. Thank you.
Richard Budden here on behalf of plaintiffs Scott Bennett and Shelby Montgomery. What I want to start with is the legal standard that plaintiffs have to meet to show causation on summary judgment, because I think this is a critical part of what the district court got wrong, and then the Court of Appeals dissent copied the error. There is a sentence in the Yunt v. Diebert case that this court decided, and in which the Supreme Court quotes Prosser and Keaton on torts, and says that, and they're summarizing the plaintiff's burden, and the important part of the sentence, it says, a mere possibility of such causation is not enough, and when the matter remains one of pure speculation or conjecture, or the probabilities are at best evenly balanced, it becomes the duty of the court to direct a verdict for the defendant. Now, as a plaintiff's lawyer, I have seen that quote in numerous defense briefings on summary judgment, arguing that, well, if the facts are evenly balanced between plaintiff's case and defendant's defense, then defendant gets summary judgment. We know that's not congruent with the standard on summary judgment. The material facts, there cannot be a genuine issue with the material facts in a case. If there's sort of a tie between the positions, that gets to go to a jury. A jury gets to decide that. And we know that because in the Yunt v. Diebert case, paragraph 1 of the syllabus sets out the appropriate standard, and it says it suffices that such evidence affords a basis for a reasonable inference by the court or jury of the occurrence of the fact and issue, although some other inference equally reasonable might be drawn therefrom. So again, if there are equal inferences that can be made from the facts for either side, that question goes to a jury. Summary judgment is not appropriate. So I would encourage this court to either clarify or somehow address that standard that gets quoted from the Yunt v. Diebert case, the Prosser and Keaton quote. I'm not entirely sure what the point of that quote was, what they're trying to say with when the probabilities are at best evenly balanced. But we know that's not the standard on summary judgment. If the probabilities are evenly balanced on summary judgment, we know that defendants don't get summary judgment at that point. A jury gets to decide the case.
What evidence was proffered to the district court showing that Horton would have changed his driving behavior, would have slowed down if Salah had ended his pursuit a couple of blocks earlier? I just didn't see that anywhere. Where does that come from?
So the facts in this case supporting causation, they start with the video and the reasonable inferences.
Let's talk about the video real quick. Can we consider the video? It was not a part of the record. You attached it to your brief. That's not how we attach evidence in the record. Can we consider the video?
Yes, the district court considered the video.
I know the district court did. It was before the Court of
video.
Appeals did. But again, can we, when it's it became a part of the record because you attached it to your brief. Would you agree with that? It's just not a part of the record in any other
The
way.
appellate record, you mean?
The appellate record.
He's talking about the appellate
The
record.
appellate record, I'm sorry.
I believe it's part of the appellate record. There's a page of the appellate record that has at least a picture of the CD, and I think it was attached properly there. If there's some procedural issue with how it was attached,
Okay.
Don't blame my client for that. But it was considered by the district court. The district court reviewed that video, and as did the Court of Appeals, from my understanding.
Right.
But that video, I mean, at bottom, the question that should be answered on summary judgment is, did Robert Horton, the fleeing suspect, would he have been speeding and driving erratically if Trooper Sala wasn't chasing him? And it's reasonable for a jury to determine yes, he was.
Let's start at the beginning here. You agree that the initiation of the pursuit was okay. No one's questioning that.
That would be justified. Correct, Your Honor.
That's justified. So the initiation of the pursuit on 20th Street, when they turn the corner onto Kansas Avenue, all that's okay.
Yes, Your Honor.
Okay. So really what we're talking about is the cessation of the pursuit.
Right. At a certain point, this pursuit becomes reckless to the point where termination is required under the statute that creates the duty to drive with the regard of safety for others, and under the Kansas Highway Patrol's policy, it's mandatory to terminate a pursuit once an officer reasonably believes that the risk of that pursuit outweighs the possible benefit to the public of an immediate apprehension. So once we have that, the proper legal standard in place, plaintiffs just have to provide sufficient evidence from which a jury could reasonably determine that this collision could have been avoided if Trooper Sala had acted reasonably. The facts with the video, I want to get into just a little bit of detail from what was discussed earlier. There's some question about the timing of everything. And plaintiff's expert did say this pursuit should have been terminated as soon as Mr. Horton blows the stop sign turning onto Kansas Avenue at 20th Street, but no later than when Robert Horton runs the stop sign at 21st Street. Now, the amount of time that happens between that and the accident are 46 seconds. So that's 46 seconds in which he could have altered his driving if the termination of the pursuit had been reasonably done. There is a point at which Robert Horton goes over the hill on 25th Street, crossing that intersection with Kansas Avenue, at which point his vehicle is no longer visible in the video. And it is no jury at that point could find that Mr. Horton could see the police officer behind him. But up to that point, between the point where he runs the light at 21st Street and when he goes over that hill at 25th Street, there are 22 seconds in that time period. And during that time period, Trooper Sala is no more than 3 to 4 seconds behind him. We're at 9:30 at night. He's got lights and sirens running. And any notion that Mr. Horton, that there's a question that he could, that he would be able to see or hear the trooper behind him, 3 or 4 seconds behind him.
How do
with
we
his
know that
lights
he can
going.
hear him? I mean, what evidence do you have? We don't know if the windows were rolled up. We don't know if he had music going. We don't know anything about what Mr. Horton was, any of his senses and what he was experiencing.
Sure.
Other than you assume he was driving down the road and looking ahead. How do we know what he was doing?
Well, it is a reasonable inference, which has to be made in plaintiff's favor at this point, that at 9:30 at night, with at least the lights going, that Mr. Horton or his passenger presumably has some attention being paid behind them, and that they can see those lights and sirens. It's present on the video. The car is, the fleeing vehicle is well within the video for these 22
That's
seconds.
looking ahead,
Right,
not,
so
not looking behind.
Right. It is reasonable for a jury to infer that the driver can see those flashing lights. We have a common experience, those of us who have broken the law on the road, which I would never admit to here, but we know that those lights, the sirens, they're very visible. That's the whole purpose of them. They're very audible, the sirens. So it would be well within a jury's experience to say, yeah, I believe Mr. Horton more likely than not was experiencing those things at that time. Even if you think his windows were rolled up, he's going fast, it would be hard to hear those sirens. It would be an unreasonable inference at this stage to say it's impossible for Mr. Horton to see those lights and understand that he's being chased. The reasonable inference from Mr. Horton's erratic driving and continuing to accelerate is that he knows he's being chased. He realizes that. That's why he's driving this way. So those are the inferences from the video alone. Then we do have our expert testimony. This is a criminologist. His studies have the studies that he is aware of show that generally, more likely than not, fleeing suspects only flee as long as they're being chased. With that and the jury's common experience,
So when
when
a chase ceases, there's an immediate response by the person being chased. Is that what you're saying?
No, but there is an immediate drop off in that person's motivation to continue. See, what the drivers.
How do we know when Horton knew?
Well, we can infer from the video that he knows he's being chased. We can infer from his driving that he knows he's being chased. There's no reason for him to be weaving in at the end of the video before the wreck. He's weaving in and out of traffic, no signals, still speeding. There's no reason for that to be
And he's
happening.
not being pursued at that point.
He is. The pursuit was never terminated.
The video only goes as long as the dash cam can see him, right? Does the video go clear to the wreck?
Yes. Yeah. It doesn't have. I think the wreck is just barely visible on the screen.
Wait, you're
but it
saying
is
the
on the whole
pursuit
time.
was never terminated? I thought the uncontroverted facts were that that Salah ended his pursuit somewhere around 25th Street?
The uncontroverted facts are that he decided that he would terminate his pursuit at that time.
Right.
But the uncontroverted facts are that he never did. There is a process for terminating your pursuit, and he never did that. That is uncontroverted. He never turned his lights and sirens off. He never brought his speed back down until right at the scene of the accident. But if we take that expert report, and if it's viewed as it should be in a light favorable to plaintiffs, if it's not completely discarded, which is what the district court did, then again, we have sufficient evidence for a jury to make this decision on causation. We have a process in place if we want to challenge the expert testimony that's being presented. And that's KSA 60-456B is the standard for expert testimony. There was no analysis done of this expert, of his bases of his opinions, of his methodology. And so it's a little circular for the district court and the Court of Appeals dissent to say, well, I'm not going to actually do the analysis required where the parties get to actually brief the bases and methodology of this expert. But at the same time, I'm going to discard it because I don't find his bases and methodology. There's no evidence of his bases or methodology. That's essentially the reasoning. I don't know what his bases are. Well, nobody challenged his bases, so I wasn't allowed to brief that. I didn't get to bring that in front of you.
Counsel, could you address, the expert's PhD is in sociology, right?
I think it's sociology and criminology, I
Okay.
believe.
And what's the basis for an expertise in car stoppage or causation from that? I mean, you're just saying since it wasn't specifically challenged, we shouldn't consider that. But is there some link between was there some basis shown in his affidavit or testimony that he actually has an expertise on this specific question?
Yes, he has done studies, he's read studies as part of his research. I realize sociology, criminology, these are soft sciences, but his awareness of the impact of chases and the reaction of people that are in that position, the fleeing suspects, that is his research wheelhouse. And in my appellate brief, at least, I cited several cases where his testimony has been used in these cases before. It's been admitted, it's been allowed. So at the very least, completely ignoring or rejecting his expertise, in this case, without even doing a proper analysis of the bases and methodologies, when he's an expert that has been relied upon several times in these cases, is improper here.
Can you shift to 8-1506 and reckless disregard in the duty? What is there to show us that Salah acted with reckless disregard?
Sure. So the standard of reckless disregard is a realization that your conduct is creating an imminent risk of harm and an unjustifiable and conscious disregard of that risk. This is a factual question. It's breach. We've got duty, breach, causation, and damages. This is the breach segment. Our breach is not just negligence, but recklessness here. But that's the standard for recklessness. The facts in support of that are that the only known violation prior to this pursuit starting was a license plate that was not properly on this vehicle. Before the pursuit began, the vehicle had been driving safely. It was not creating any danger to anyone nearby.
Wasn't there a part of at least Salah's consciousness of why he was pursuing this vehicle was not only the license tag, but also a knife, someone wielding a knife in the car, and he didn't have any other information about that than what he heard on the radio.
The information that he had been given was another trooper earlier had seen someone waving what looked like a knife to him, and at some point they faced the driver. But he also said that this trooper said, I couldn't tell if this was an aggressive move or what it was. He just described it as strange movements with the knife.
Doesn't that factor in?
Sure, there's a potential danger going on there. Pretty quickly after they start accelerating, that Toyota going 50, 60, 70 miles an hour on Kansas Avenue on 20th Street is a much greater risk to a lot more people than somebody who might be swinging a knife in a car. And there was no knife found. I mean, that may not be relevant. There was no knife found. The man that was swinging the knife was a teenage girl. But even assuming those facts in Trooper Sally's justification, he's got a potential knife danger in that car. He knows there's a tag violation. It's pretty soon after that chase becomes high speed that he should know okay, the risk here is greatly outweighing the possible reward of pulling over someone with a tag violation. This pursuit took place in the city limits of Topeka on Kansas Avenue, which we're all familiar with. Defendant Sally knew that was a main thoroughfare for traffic. He admitted that he knew the pursuit was futile early on. His testimony was, I knew at that when he ran that light at 21st Street that this chase was not going to be very productive. That is evidence in our favor of his realization that this conduct was creating a risk that was not justified. And because because of his basis for this chase was such a low level of danger to the public or anyone, quickly that this risk of the chase is unjustifiable, and disregarding it consciously makes it reckless. Now, this court in the Robbins case, which is kind of like the last seminal case on police chases, decided that the officers there were not reckless, and the reason because the person that they were chasing was a drunken, violent, axe-wielding, fleeing suspect that the court said put anyone that he was near in danger. So at that point, when the standard is that you have to show an unjustifiable disregard of the risks, it's not unjustifiable to continue chasing this guy even when the pursuit becomes very dangerous. You've got a dangerous criminal in that car. You're still justified even incurring those risks. Here, we don't have any risk remotely related to an axe-wielding, drunken, violent suspect. So the justification for this chase goes away pretty quick. You're unjustified, or at least a reasonable jury could find that this pursuit is unjustified very early on, and based on what we provided the district court, a reasonable jury should be able to determine that if this termination had occurred at a reasonable time before that 21st Street light, there was ample time for Robert Horton, the fleeing suspect, to change his route somehow or slow down, not accelerate as fast as he did, in a way that avoids this collision altogether. Any other questions? Thank you.
Plaintiffs argued that the pursuit was reckless because Horton ran through the red light at high speeds. If that were true, then almost any police chase would be reckless. They almost always involve high speeds and running through a red light or a stop sign. But if that's the holding, then as the U.S. Supreme Court explained in Scott v. Harris, that would create really perverse incentives. It would tell suspects that all they need to do to avoid police is speed up and run through a red light, and the police can no longer chase them. That can't be the standard for recklessness. As this court discussed in Robbins, in the cases cited there, recklessness is a much higher standard.
I'm not sure I heard that from the plaintiff's argument. I thought they were asking more for a balancing of what the risk versus the reward was in effect.
Well, in this case, they're claiming that the recklessness occurred when Horton ran through the red light at high speeds at 101st Street. The only other aspect to that, I guess, is the seriousness of the danger, and they tried to minimize that here by saying, well, it was only a mismatched tag. Well, there's a lot more to it. There was the knife. There was the suspicion because of the tag that it was a stolen vehicle. There was also the fleeing itself suggests substantial criminal activities going on. In fact, it turned out that Horton had a minor runaway child in his car with him. So there was a lot going on. And it's not really all that different than Robbins. They quote the knife-wielding, axe-wielding drunk guy quote. But in that case, the officer testified that he wasn't even aware whether Robbins had an axe with him at the time. And in that case, the offender had tried to break into a house and then was leaving the house. So it wasn't an imminent threat there any more than here. It was a very similar type of situation. Also, the plaintiffs quoted or ascribed a quote to Trooper Salah saying he knew the pursuit would be futile. That's incorrect. The record does not reflect that. What he said was he had hopes at that point that he could stop the car, although it didn't look like it was going to be productive. That's very different than saying I knew it wasn't going to be productive. He was still, in that roughly 20-second period, still believed that there was a possibility that Horton could be stopped. Also, I understand plaintiffs to say that, or to agree that it's that 22-second period that we're talking about between the light at 21st Street and the time Horton goes over the hill at 25th Street. And they claim that, well, Trooper Salah was immediately behind Horton and could have terminated the pursuit at that point. But as I mentioned earlier, in order to terminate the pursuit, he would have first needed to slow down to the speed limit before turning off his lights and sirens. KSA 81506 requires that. And by the time he was slowing down, Horton would have been long ahead of him at that point. So it's really questionable, A, whether Horton would have noticed the termination, and B, whether how he would have responded. To clear up one perhaps factual confusion about when the pursuit terminated, Trooper Salah testified that he decided to terminate the pursuit near the Wonder Bread store, which is just south of 25th Street. But again, he was at that point traveling, I think, 90 miles per hour or so, so he couldn't immediately turn off his lights. And he didn't actually complete the termination of the pursuit by the time of the collision. But he did testify that that's when he decided to do it. It takes some time to terminate a pursuit because you first have to slow down. Unless there are any further questions.
Mr. Carswell,
Sure.
is it your understanding, or was it your understanding, that the video is in the record?
I believe it is my understanding. Now, I wasn't involved at the Court of Appeals level, so I may be wrong, but my understanding is it was attached to the summary judgment briefing below and therefore became part of the appellate record.
Thank you.
Well, we can at least be clear that in your petition for review, you didn't claim it was error for the Court of Appeals to have reviewed the video.
That's correct.
Because, I mean, it's sort of all over.
And we think the video helps us. I mean, it shows how deserted the roads were. It shows at 21st Street that the cars on either side had stopped and that there was no. So, yes, we believe the video is in the record. But is there any further questions? I urge you to affirm the district court. Thank you.
Thank you. Court will take this matter under advisement, and we will